Good afternoon, everybody. I hope everyone can hear me. I'm not a really loud talker, so I apologize. I would first like to thank Double Apple from Roanoke, who catered our lunch today. So they're not here, but they're with us in spirit. So thank you for being here today. I'm Christina Becker, the editor-in-chief of the Journal of Civil Rights and Social Justice. I would first like to thank the panelists and moderators for their hard work and contribution to our symposium. I would also like to express my gratitude to Monica Tolchinsky, who worked tirelessly to put this event together, as well as all the support from the Journal board and staff. And finally, I would like to thank our guests for joining us today. I'm so pleased to be here and involved in this event and to have the honor of introducing our keynote speaker, Nancy Hollander. Ms. Hollander is an internationally recognized criminal defense lawyer, currently at the firm Friedman, Boyd, Hollander, Goldberg, Urias, and Ward in Albuquerque, New Mexico. She is a past president of the National Association of Criminal Defense Lawyers and was named one of America's top 50 litigators by the National Journal in 2001. Ms. Hollander has also co-authored several books on criminal defense and procedure. Additionally, she has argued and won a case on religious freedom in front of the United States Supreme Court. Now, I looked up this case so I could give you all the name of the case, and then I saw it was a Latino church in Texas with about 6 names, and I would just absolutely butcher the Spanish. So I thought I would spare you all from that. Ms. Hollander's international career is equally as impressive. She consulted on a high-profile terrorism case in Ireland, to the United Nations Development Program in Vietnam, and various other international cases. She also currently represents 2 Guantanamo Bay detainees and is lead counsel for the Special Tribunal for Lebanon. Ms. Hollander also gives back to her fellow defense lawyers by having taught multiple trial practice courses and international seminars, training courses for lawyers appearing before the International Criminal Court and the International Criminal Tribunal for the former Yugoslavia, as well as a jury trial training project in Russia. Today, Ms. Hollander will be discussing one of her landmark cases, the Holy Land Foundation case, and her struggles battling America's perception of Muslim Americans. It's my absolute pleasure to introduce you to Ms. Nancy Hollander.
Thank you, and it's my pleasure to be here and to talk about Holy Land. This is not a terribly uplifting discussion, unfortunately, although we've heard about what we can do in the future. Maybe together we can come up with what we can do to right this particular wrong. Because I want to spend this time talking about this case. It's a tragic but true story about the case against the Holy Land Foundation and 5 Palestinian American Muslim men who worked for that organization. It started for me when Holy Land was designated as a foreign terrorist organization, especially designated terrorist organization, in 2001. And then it became a criminal case against Holy Land and those 5 men, and ended in long jail sentences. My client, Shukri Abu Bakr, is serving a 65-year sentence for providing charity. That's what they were accused of, and that's what they were convicted of. So what I want to do through the events that I'm going to tell you about is tell you how when we talk about terrorism and when terrorism comes into the framework, the rules change. The law doesn't apply as we know it, and the facts don't really matter. Even rights as basic and fundamental as the Confrontation Clause that we all believe we can rely on in this country, that you have a right to confront and cross-examine your accusers, were completely violated in all of these trials and affirmed on appeal. And this was all in the interest of national security. That was the backdrop, national security and terrorism. But as you'll come to understand, this case involved nothing more than the provision of charity. Food, medical supplies, wheelchairs, backpacks filled with school supplies, just charity. The Holy Land Foundation and these men, as I've said and will say again, were never accused of, never charged with, and never convicted of a single violent act. The story actually begins in 1986, when a young baby was born. Her name was Sanabel, and she was born to Shukri and his wife Wijdan in Indiana. And they are both of Palestinian descent. Sanabel was born with two devastating inherited conditions, and required a great deal of care from a hospital that was able to provide it in Indiana. Fortunately, now, 26 years later, Sanabel is still alive. But she would not have lived for more than a few months had she not had the best medical care that could be provided. And Shukri, who at the time was working as an accountant and got most of this care for free in a hospital, realized that if Sanabel had been born in his homeland, in Palestine, the land of his ancestors, she'd have never made it. And that the children in Palestine were suffering. And it was based on that he conceived of the idea of the Holy Land Foundation for Relief and Development and started this foundation. Over the years, from 1986 until 2001, Holy Land raised and gave away millions of dollars to national disasters, hurricanes, tornadoes, man-made disasters. The Holy Land arranged a blood drive after Oklahoma City bombing. But most of their focus was on the people in their homeland, just as many charities focus on particular people, and it was on Palestine. No one ever disputed throughout the years that we worked on this case that the situation in Palestine was desperate. The government's own expert, Matthew Levitt, who considered himself an expert on Palestine, recognized the plight of the Palestinians as desperate and said it in trial. But in the late 1990s, Holy Land was going along, raising millions of dollars, giving it away, and reports began to appear in the media that the government was investigating Holy Land for supporting Hamas. Nobody quite knew at that time why these reports were coming out. But I assume most people know now the origins of Hamas, but it's an organization in Palestine that grew out of the Muslim Brotherhood there, and it was created in 1987 in response to the First Intifada, which was a spontaneous uprising in Palestine. No one contests, no one on any side of any issue contests that this was a spontaneous uprising, a revolt by Palestinians against Israeli occupation of their land and virtually complete control of their lives. I don't want to get diverted too much into Hamas, except to say that Israel originally welcomed Hamas as a counter to the Palestinian Liberation Organization, and thought that a religious organization, which is what Hamas was, would be helpful. And that lasted for a while until Hamas began suicide bombings inside Israel. And obviously at that point, Israel declared Hamas a terrorist organization and outlawed it. In response to this violence, the growing violence, and the suicide bombs, the United States banned financial support to Hamas. And the date is significant. It's January 25th, 1995. President Clinton issued an executive order under the International Emergency Economic Powers Act, known as IEPA. And that date becomes significant. In 1997, the United States criminalized financial support for Hamas in a slightly different way, calling it a foreign terrorist organization, and that brought it under the prohibitions of 18 U.S.C. 2339B, which specifically makes it a crime to provide any support to a designated terrorist organization. So, what was Holy Land doing? Holy Land provided its support and its charity through, primarily, originally, through what are called zakat committees. I don't know what the exact translation is, but for all intents and purposes, these are charity committees. And they exist throughout the Muslim world because Muslims are required by their faith to provide charity if they are able. And the way most Muslim countries have set this up is to provide these committees. So they're usually in each town or area, and the people who run them are usually the wealthier people in town who get together as volunteers, so that if someone, for example, in the United States wants to give money in Palestine, they don't know who are the poor people, where it's going to go. They give it to this committee, and the committee then gives it out, and there's very little overhead. But some of them have gotten very big. In Palestine, the Jenin Zakat Committee runs a hospital. They sometimes provide animals to people who are starting farms. They run dental clinics. They provide school supplies. They open schools. And they've just been in existence for hundreds of years throughout the Muslim world. The specific Zakat committees that Holy Land contributed to, not one, to this date, now several years after Holy Land's the convictions, has ever been on a designated terrorist list in the U.S. And this is very important to understand, because the designation process serves two critical functions. And the head of the designation process is primarily handled through the Office of Foreign Asset Control from the U.S. Department of the Treasury. And the head of that office explained at one time, and I'll quote, that the designation of an entity alerts the world to its true nature and cuts it off from the U.S. financial system. That's the whole point. Now, the government admitted, and has always admitted, that it didn't become illegal to support or fund Hamas until 1995. At that point, the Treasury Department maintained this public list. And you can go on the website, the Treasury Department, and designated terrorists, and you'll find this huge list. And there's several different lists. But there are hundreds and hundreds of organizations, foreign terrorist organizations, specially designated terrorist organizations, specially designated global terrorist organizations. They update it every 2 weeks. You can get on their list, and they'll even tell you, we took this guy off this week and we put this guy on. It's a totally public list. And the purpose of it being public is so anybody knows. For example, lawyers like myself, I check that list every 2 weeks because of the clients I represent. I want to make sure I'm not representing someone on the list. And if I am, then you have to get a license from Treasury, and so you have to be careful. That's the purpose of the list, so it will be public, so everyone will know who you can't give money to. This list includes people and entities that were determined by the U.S. government to be, quote, owned or controlled by or to act for or on behalf of Hamas. Hamas was designated. Several Hamas officials appeared on the list starting in 1995, but not a single one of the Zakat committees that Holy Land ever gave money to. To this day, they don't exist on the list. But when these reports began to appear in about 1997, Holy Land retained a lawyer and a former congressman, John Bryant, Dallas, Texas, and said, what do we do? Why are these reports out in the media? So John Bryant went to Washington. He met with the FBI. He met with the State Department. He met even with the Israeli embassy and said, we want to make sure that Holy Land's money is legal. We want to make sure Holy Land can continue to provide relief to Palestine, primarily to children and orphans. Who shouldn't we be talking to? Who shouldn't we be giving money to? And no one would tell him. The government refused to provide any kind of white paper and said, look at the list. Just look at the list. That's why we have it. And that's what Holy Land did. And everything went along okay until 9/11. The world changed. Regardless of what anyone says, the world changed. No one ever thought Hamas had anything to do with 9/11, of course. But now Muslim charities, Muslim in America, were suspect. On December 4th, 2001, the FBI raided the Holy Land offices, their main office in Dallas, an office in New Jersey, Illinois, and California, and took everything. Everything down to the plants. I mean, literally, everything. All the paper, every document, all the office supplies, the offices, the chairs, the tables, everything. And notified the banks where the money was that the money was to be frozen. Ramadan had come in November of that year. And Ramadan, the month of Ramadan, is when the Holy Land did most of its fundraising, because that's actually the month when Muslims give the most. So there were millions of dollars, I think approximately $12 million or more, in the banks waiting to go out as charity. And that money was frozen. So why did this happen? HLF never gave a dime to Hamas, and it sought guidance from the U.S. government. But there was something else going on at that time, and that was at the policy levels of the White House and the Treasury, they wanted to be very public and very aggressive to show that they were dealing with terrorism. And one of the ways they did it was to start designating terrorist organizations. There was a decision made to have a major designation every 4 weeks. And they admitted later that the evidentiary foundations for some of these were a little weak. Paul O'Neill was George Bush's Treasury Secretary at the time. And he actually wrote about this in a book, a little-known book, but that we found. The title of the book is The Price of Loyalty, George Bush, the White House, and the Education of Paul O'Neill. It's written by Ron Susskind, who was his biographer. In that book, he said, and this again is a quote, that after 9/11, all there was to do was seize some assets, and quickly. The president was to announce the new executive order on September 24th, launching the war on terrorism. He needed some assets to point to. David Aufhauser, who was general counsel to the Treasury at the time, said it was almost comical. We just listed as many of the usual suspects as we could and said, let's go freeze some of their assets. And that's what happened. That's when Holy Land got caught up. And that's when they then hired us to try to overturn the designation. So this became a civil case, a lawsuit against the United States to overturn this designation. And there was, because it was an administrative case, there was an administrative record. And the administrative record was nothing more. It's a huge record, but it's newspaper articles, anonymous statements, nothing under oath, and some secret evidence that we were never allowed to see, even though myself and my co-counsel had security clearances that we had already because we'd handled other national security and espionage cases. That didn't matter. The secret evidence we never got to see. The most significant document was actually an Israeli summary. It was a summary that had come from the government of Israel. And it was from alleged statements from a guy named Mohammed Anati. Anati, what Holy Land had done was, as it got bigger, it had actually opened its own offices in the West Bank so that it didn't have to send money through the Zakat committees anymore. It just cut down on overhead. It had its own social workers. It would go out and find the families that needed funds and find the kids who needed school supplies, hospitals that needed wheelchairs and medical supplies. And this young man, Mohammed Anati, a Palestinian man, lived in Ramallah, and he ran the Ramallah office. And he also worked through the Ramallah Zakat Committee. The U.S. requested Israel to arrest him, and Israel did, and interrogated him. But his statements, his actual statements, once they were translated and actually put onto the record, were much different from the summary. For example, he insisted repeatedly that Holy Land had no connection with Hamas, didn't fund Hamas, didn't give preference to Hamas orphans and families. But the original administrative record contained this summary, which had come from Israel, also contained his actual statement as written down in Hebrew. What happens with these interrogations in Palestine is that the Palestinian generally says it in Arabic, then it's translated by the interrogator into Hebrew. And we actually had the whole thing, but the government hadn't evidently bothered to translate it. They just accepted the summary. Well, we had it translated, and it turned out that, for example, the administrative record says, quote, Anadi stated Holy Land provided aid to the needy, but some of the aid was channeled to Hamas. Well, that part wasn't in there. The administrative record said Anadi enabled every branch to allocate the money freely, but since some of the heads of the branches were connected with and supporters of Hamas, some of the money served Hamas. Except that wasn't in there. And there were several other examples. And in addition to relying on this misleading summary, the government omitted Anadi's sworn testimony that he gave before the military court in Israel. Anadi, we found his lawyer, a famous Israeli civil rights lawyer, her name is Leah Semmel, and she had represented Muhammad in front of the military court in Israel, and she provided us his statements under oath, where he said, I knew everything about the organization. It did not go to Hamas, and if it had, I would have quit. Anadi, by the way, was released because there was no evidence against him. But those statements didn't matter. The government said, well, we're sorry, the summary was a little bit wrong, but what difference does it make? Because it didn't make any difference. It didn't matter. We put in all kinds of sworn statements. It didn't matter. The government conceded that it had designated Holy Land without any notice, without a hearing, without a warrant. But the court, the district court, the United States District Court for the District of Columbia, and the appellate court affirmed and granted the government summary judgment. Now, some of you, I'm sure, are studying civil law, and you know that before you get a grant of summary judgment, you get to do discovery. But not in this case. No discovery, no cross-examination. Just looks like it, and by the way, we're also considering the secret evidence that Holy Land's lawyers never got to see. No court, and the Supreme Court denied cert, no court ever required the government to present a single live witness for a cross-examination. This was the largest Muslim charity in America. It never had any opportunity to cross-examine or examine a single government witness, didn't even know who some of them were, didn't know what the secret evidence was, and we've never learned what that secret evidence was. This was all based on the need to protect national security. And I remember going to the oral argument and one of the judges saying, well, this case is just different. It's just different. We have national security here, so the rules don't apply. And Amara talked about some of this history, and you got to go back and think, what was the security that was being protected here? Think about the Japanese who were in the Korematsu case. What was the security that was protected then? It took us 40 years to figure out that we were wrong. Think about the Pentagon Papers. My God, we cannot publish the Pentagon Papers or the world will come to an end. Well, they got published and the world didn't come to an end. Think about right now, today, the trials in the military commission, the trial of Khalid Sheikh Mohammed or the trial of my client, Ibrahim al-Nasri, that we have to do there. We can't do them in New York because it'll be too dangerous. Except, of course, there have been 100, I believe, 100 terrorism trials in New York since 9/11. And last I heard, New York is still standing. there was no semblance of due process. And of course, the desperately poor children never benefited from the millions of dollars that remained locked up in the banks. That was a civil case. It involved money. And it came to an end. And Holy Land was closed, and we thought it was over. Then it got much worse. And as you've heard, things kind of ratcheted up after 9/11. Well, 2004, Holy Land, which didn't even exist anymore, and these 5 men were all indicted and tried in the Northern District of Texas in Dallas. They were charged with providing material support to Hamas, conspiracy to provide material support to Hamas, conspiracy and violating IEPA, money laundering, filing false tax returns, a huge number of counts. And the trial began in 2007, 3 years later, before the Honorable A. Joe Fish in Dallas. The indictment alleged that the money had gone to these 7 Zakat committees. They were all located in the West Bank, and their names are the names of the towns: Qalqilia Zakat Committee, the Islamic Charity Committee of Hebron, Tulkarm, Jenin, Nablus, Ramallah, and the Islamic Science and Culture Committee. The government traced every dime and traced it all accurately. And every dime that left Holy Land went to the Zakat committees and then went to charity. The government never traced a dime anywhere else. Nor did it ever contend anything else. In fact, during one of the closing arguments, the government prosecutor said, and I quote, "No one is saying the defendants themselves have committed a violent act or that Holy Land funds went directly to buy a suicide bomb or belt." The government's theory was that since there were people in these Zakat committees who were Hamas supporters, therefore Hamas controlled the Zakat committees, and by distributing humanitarian aid, Holy Land helped Hamas win the hearts and minds of the Palestinian people. That was the government's theory. Now, one thing to keep in mind is that all these Zakat committees were legal. They had been licensed, depending on what year, either by Jordan, depending on when the West Bank was under Jordanian control, or by Israel, or by the Palestinian Authority. So they were all licensed organizations. They all had boards of directors, generally that came from all political spectrums on each board of directors. There is no doubt that the Treasury Department has the authority to designate terrorist organizations. Interestingly, in August of 2007, during the first Holy Land trial, Treasury designated a Zakat committee. Excuse me. It was in Gaza, not in the West Bank. It's the Al-Salah Committee. It was the Al-Salah Society. It was a Zakat committee in Gaza, and designated some of the people who worked for it, and designated it specifically based on its relationship to Hamas. So there is no doubt that Treasury can do it. At the time it did that, the quote from the head of OFAC was, "This new U.S. designation criminalizes American donations to Al-Salah and officially informs banks and donors of the organization's ties to and activities on behalf of Hamas." But the government's theory in prosecuting Holy Land was basically that donations to Al-Salah had been, quote, criminalized since 1995, when Hamas was first designated, even though it hadn't been designated, because that was its theory against Holy Land. Edward Abington was the U.S. Consul General in Jerusalem from 1993 to 1997, and essentially the ambassador to the Palestinian Authority. He served for 30 years as a foreign service officer, and before that worked for the CIA. He reported to the United States State Department. Ed Abington testified in the Holy Land trials that he had been briefed that he was to have nothing to do with Hamas. Don't talk to Hamas. Don't talk to anyone from Hamas. Don't go anywhere where there's Hamas. But that he had been to all of these Zakat committees, the same ones that Holy Land supported. And that he had never heard about any link between Hamas and the committees from the United States side, from the Israeli side, or from the Palestinian side. The United States Agency for International Development, USAID, also has strict instructions not to deal with Hamas. This is a U.S. agency that provides charity around the world. It provided funds for many years to the same Zakat committees, including Jenin, Nablus, and Calculia. And we were able to get this information largely through discovery and some through a Freedom of Information request that we made. We found that in 2004, the same year that Holy Land was indicted, so you couldn't say that the government didn't know, USAID provided $47,000 to the Calculia Zakat Committee. And this all came into evidence. Over 10 years, we discovered the government had been wiretapping Shukri and his co-defendants. And by wiretapping, I mean they had tapped their phones, they had their emails, they had all the faxes, they had put things in their houses and in the office, they had cameras, all kinds of stuff. It was all through the Foreign Intelligence Surveillance Act, FISA. There are two things of significance about that. One is that means that the government knew. It's not that they found out later where the money was going. They knew all along where the money was going because they had intercepted every fax that went saying, this is the Jenin, Zakat Committee, we have received your contribution of such and such. This is Holy Land, we are sending you this money. And the money went through wire transfers, and they had all of it. And they had it at the time it was happening. The second thing about this is that there's a rule of criminal procedure, Rule 16. And that rule, which allegedly applies in all federal prosecutions, requires the government to disclose to the defendant any relevant conversation or recorded statement by the defendant. So we had 10 years of FISA wiretaps. They were in Arabic. There was no way that the lawyers were able to sort through these. We had clearances. Our clients didn't. The government said, well, those are all classified. Clients can't have those. And it would be a national security problem if they saw them, but they were their own statements. They theoretically knew who they had spoken to. They never got to see them. The court also admitted documents that were found in the homes of two other individuals, not on trial. These were documents that allegedly portrayed Holy Land supporting Hamas. This was blatant hearsay. These were, I call them documents, but some were scraps of paper, handwritten, no provenance. Who knows who wrote it, when, but it was found at these men's houses. The government said they were co-conspirators, even though these documents were dated before 1995, when it would have been perfectly legal to support Hamas in any event. The government said, these are co-conspirator statements under a joint venture theory, and the court, of course, let them in because the court basically let in anything the government asked for. And then it got worse. For the first time in the history of an American trial, an expert was permitted to testify anonymously. The defense was never able to know anything about him, or even if he was who he said he was. Joshua Draytell, one of my co-defendant and co-counsel, we're not yet co-defendants, co-counsel, although Joshua and I did travel to Gaza together and almost didn't get out of the place, but he was cross-examining this man who we only knew as Avi And he said, Avi, he said, you say you're a lawyer with the Shin Bet. That's the Israeli security agency. You say you're a lawyer with the Shin Bet, but you could be a Mossad agent and we wouldn't know, would we? And his answer was, that's right. You cannot research me. He was allowed to opine based on criteria that he selected that these Zakat committees really were Hamas. And I'll quote one sentence from the first trial. He said, we saw it in the keychains, again in the videos, posters. It's all around them, everywhere. The color of Hamas, the smell of Hamas, it's everywhere. That was his testimony. We never knew anything about him. And there's only a few times in American jurisprudence that any prosecution witness, expert or not, has been allowed to testify without disclosing his identity. Decades ago, the U.S. Supreme Court said in Smith versus Illinois that such a procedure effectively eviscerates the right to cross-examination. This was an unprecedented ruling that violated all Fifth and Sixth Amendment rights that we thought existed in the Constitution. But there was worse. The jury saw repeated pictures of burning buses that are the result of suicide bombs. But no defendant was accused of burning a bus. The jury saw a videotape of demonstrators stomping on and burning an American flag. No defendant was accused of stomping on or burning American flags. There were violent images that they had pulled off the computers. There were explanations of how suicide bombers choose their targets, how they carry out their plans. There was discussion about how Hamas kills collaborators with Israel. It was, videos of school children marching around with Hamas flags in schools that years after Holy Land had been closed, that Holy Land had not given a dime to. With all that came in, and I've only talked about the worst of it, with every hearsay objection overruled, every confrontation objection overruled, except one that I'll talk about in a minute. After 8 weeks of evidence, and the jury took 20 days of deliberations, not one conviction. There were some partial acquittals and mistrials as to everyone else. Not one. The jury saw right through all of it. And then there was the second trial. The second trial took place a year later. After 6 weeks of evidence and 9 days of deliberation, the jury found everyone guilty. So what was different? Once again, they heard from Avi. Once again, they heard about the suicide bombings. Once again, they heard irrelevant questions about Iraq and Saddam Hussein that had nothing to do with it. They saw fiery speeches from Abdullah Azzam requesting people to join the Mujahideen in Afghanistan and looking very much like everyone now thinks of as the Taliban. And we weren't able to go back and explain the history that this was 1998, first of all, that he came with an American visa, that the United States was supporting all this, because if we got into that, then the government was just going to go right into Al-Qaeda. And the only thing we were able to keep out was Al-Qaeda. So we were stuck, and they kept seeing these pictures over and over again, burning buses over and over again, and all the material that came in. And all of that came in just like it did in the first trial. A little bit worse than the second trial. But there were 4 specific areas of evidence in the second trial that were significantly different. The government, basically having lost the first time and knowing we had a different judge this time, Judge Solis, but knowing that the judge was going to grant every wish in the government, this is what they did. First, the court permitted the government to call a former National Security staff member, Stephen Simon, He testified about vital U.S. interests and that Hamas violence threatens to increase the risk of another 9/11 style attack on the United States. He wasn't even noticed as an expert. This was allegedly lay testimony, although clearly expert opinion. And it was irrelevant. It was highly and unfairly prejudicial. It appealed to the jurors' fears that if they allowed this, there would be another 9/11 style attack on the United States. On appeal, the Fifth Circuit agreed with the defense that this should never have come into evidence, that it was unfairly prejudicial, irrelevant, and inflammatory. The second thing the trial court permitted the government to call an expert from the Office of Foreign Asset Control. Now you recall, that is the very office that designates organizations as foreign terrorist organizations. His name was Robert McBrien. He also, we never knew about him as an expert. He was supposedly giving non-expert lay opinion. But he said, well, the defendant should have known they couldn't give money to these zakat committees even though they weren't designated. The trial court allowed him to testify about the core issue in this case as a lay witness and present expert testimony. The Fifth Circuit, in their opinion, again agreeing with the defense, said, and I quote, "The defense argued that McBrien was not noticed as an expert witness, that his testimony was improper lay opinion, and that he gave an improper legal conclusion. We agree with the defendants." The third thing the government did was introduce the evidence of an informant. His name was Mohammed Shorbaji. He'd been convicted of a massive fraud against his employer, having nothing to do with Holy Land, but he was offered a deal in that case if he would testify against Holy Land. And he had worked briefly for Holy Land. And he said, well, everyone in the West Bank knows that Holy Land provides money to Hamas. Shorbaji had never been to the West Bank in his entire life. He was from Gaza, and he hadn't even been to Gaza since 1991. This case was being tried in 2008. He testified that he knew this from newspapers, from leaflets, from Hamas itself, from the internet, and from talking to friends. He said, everyone on the West Bank knows this. The Fifth Circuit again agreed with the defense that this was all completely unreliable hearsay and should not have been admitted. Fourth, the government offered 3 documents from the that the Israeli Defense Force had seized from the Palestinian Authority. Now, this was one that we had actually won in the first trial. In 2002, Israel invaded the Palestinian Authority under something called Operation Defensive Shield. They actually went all over the West Bank and got a lot of documents, many of which came into this case. But these were specific. They were in the Palestinian Authority offices, allegedly. Of course, the other anonymous witness we had was the custodian of these documents who came in and claimed that that's where they came from. 2 of them had unnamed authors and relied on unnamed sources. And they purported to describe the Hamas fundraising network and identified the Ramallah Zakat Committee as being part of that network and saying that Holy Land provided funds for it. Judge Fish in the first trial had excluded these as clearly hearsay. But Judge Solis, who admitted everything, admitted them. The government got them in under the catch-all exception, the Rule of Evidence 807. Look it up if you're not familiar with it. It's not a way to just get in any hearsay that you feel like. We had argued successfully in the first trial, and obviously unsuccessfully in the second trial, that there was nothing known about the circumstances of these documents. There was nothing known about how or where or when they were created. There was nothing known about the duty of the authors to prepare the documents. What procedures, what methods, how did they reach their conclusions? Essentially, what were the circumstances of reliability? We didn't even know the identity of 2 of the authors. These were handwritten documents. The Fifth Circuit, again, agreed with us. For the fourth time in its opinion, and I quote, "We conclude that the government's justification for admitting the documents was insufficient to prove their trustworthiness, and they should have been excluded from the second trial." So you might wonder why it is that their convictions weren't overturned. All this evidence was admitted in the second trial that wasn't admitted in the first trial. There was a mistrial in the first trial, even with the bad evidence that came in. You add all this more, and they all get convicted. But the Fifth Circuit said, well, you know, it's a national security case, so it's all harmless. Harmless. The law didn't matter. The facts didn't matter. What mattered was that these were Palestinian men providing charity and feeding Palestinian children, and in the name of national security, we simply could not let it happen. The Supreme Court denied cert. Shukri and one of his co-defendants received sentences of 65 years. The others received sentences of 15 to 20 years. Interestingly, at about the same time, there was a sentencing of a man named El-Mari, who had entered into a plea with the United States and admitted that he was a sleeper agent for Al-Qaeda, had come into the United States on September 10th, 2001. He received a sentence of 15 years. And when I pointed this out to the judge at Shukri's sentencing, he said, well, that was just one act. Your client was a lifelong supporter of Hamas. Of course, Hamas didn't even exist during most of my client's life, but that's what the judge said. Also, interestingly, in Israel, there have also been prosecutions. And the biggest one involved Palestinian men who were accused of providing charity to Palestinian organizations that Israel said supported Hamas. But the Israeli sentence was 5 years. Neither trial contained any evidence, not from the secret 10 years of wiretaps, not from the anonymous documents, nothing, that Shukri Abu Bakr advocated violence against Israel. Not a word from his lips that he hated Jews. Not a word from his lips that he supported Hamas. These were fictions that the government foisted on the courts. We're hoping there'll be a habeas. I hope they find something we did wrong. Otherwise, I don't know how we get these people out of jail. It's difficult to imagine now that any American will be willing to support the Palestinian people, because the government has shown that OFAC, designated terrorist list, doesn't really mean anything. It can't be relied on. The government can come back later with somebody like Avi and say that an undesignated group was actually forbidden. I have a client who's Syrian, and he asked me recently, he said, you know, they're refugees. I want to help. This man has a great deal of money, and he said, I want to help the refugees. There are zakat committees. Can I give to them? And I said, no. Because today they might be all right, but then tomorrow they might come back and say, well, you should have known that they were somehow linked up with Hezbollah or Al-Qaeda or who knows what. So don't give to those. We'll find another way to get this money to these people. If we have to fly there to the refugee camps and hand it out directly. And I have another client, a Muslim client, who said, we're just going to go to the West Bank and we're going to slaughter a lamb and you can go with me and we'll go door to door in the refugee camps and hand it out. Because that's the only way to do it, and that might not even be safe. The Holy Land case is, I believe, the Korematsu case of this generation. Korematsu upheld the internment of the Japanese Americans during World War II because we believed that it was a national security issue. There are other issues. There are the race-based issues that Amar's talked about, and that's all true. But the one to me that is the closest is Korematsu, because it was based on prejudice and fear, and the law and the Constitution were ignored. Holy Land has imprisoned 5 innocent men, 2 of them for the rest of their lives. It was unconstitutional. It was unfair, it was based on prejudice, it was based on fear, and frankly, it brings shame to the American justice system. It's going to be up to us. We've talked about looking forward, and I always hate to end by saying what a tragedy this is, but it is. But it's up to us, it's up to the people in this room and the people in this country to take back our justice system and to demand that it be fair to everyone. And that's our goal. Thank you for listening.